DFO, Divisional Forest. I know, Lordship, it is the poaching which is we want to curb. Pangolin is an endangered species, Lordship. They kill it and make leather bags and other things, Lordship.
But in UP, where do you get these pangolins?
Your Lordship, there are few, Your Lordship, only now few rare species which are left.
Yes.
I'm grateful for the
Lordship thesis. Because last time, Honorable Court was pleased to protect the millers. That the lady has been served, my wife has been served. It has no appearance, my lord.
There's a development in the matter. Time to file counter, my lord.
So one development I must mention also very honestly. Before the High Court yesterday, the lady appeared, my client also appeared, and both made we are negotiating a settlement. And the High Court has kept the matter on 13/12. Because she has approached the husband, my client.
So if she has approached the High Court, we dispose of the matter.
No, my lords, the request is that the High Court kept on 13/12.
On this matter,
one adjournment. Why I'm saying so, my lords, today, High Court was requested to grant the protection yesterday.
We'll request the High Court to proceed with the
High Court matters kept on 13/12. Kindly consider.
So, okay.
Lordship, the interim order may kindly be done for some more time, my lords. In the interim, because parties have now, as I promised to your Lordship Court on the previous occasion, although there's an MOU, I have paid the entire.
I have not filed anticipatory bail.
We had filed anticipatory bail, granted. Then we move for quashing. The court, kindly give me 1 minute. The court allowed interim orders.
Again, permitted you.
No, the High Court said at the earlier stage, High Court granted interim order in the anticipatory bail application. Then I moved for quashing. High Court entertained my quashing, granted him interim order. High Court said that since we are granting interim order here,
you did not pay the cost.
No. I'm sorry. I'll never do that. Then the High Court disposed the anticipatory application on the ground that we have entertained your quashing matter, we have granted your protection, therefore this is disposed of. And then, my lords, on the last occasion, the High Court did not grant extension. I came to your Lordship Court because of my lord's indulgence. The wife, the ex-wife has approached the husband, although Lordship may recollect, in the family court. MOE has been executed, decree of divorce is given on settlement. I paid the entire money, but she had some more desire. So I have
asked for the protection from the High Court. We will give you further protection of 2 weeks. In the meantime, you approach the High Court and.
The Lordship may say, because the High Court is getting 13/12. Lordships are aware.
You approach the High Court.
I'll do that, but kindly consider to grant extension to 13/12.
No.
I'll move the High Court.
Not till 13/12.
Today, please consider my predicament, I have joined the family court.
Application for protection.
Yesterday I made request to the High Court. High Court says, High Court recorded a statement of both the parties. The lady also was before the.
1 minute. You are, what is
my lord, I am for the government, my lord.
Yes.
On a number 1, I am City of Delhi.
Are you arresting him or?
No, my lord, I have just appeared for the very first time, my lord. I need to seek instruction, my lord, as what is the stand of the government in this matter. So I will file my counter.
You want to detain him?
No, my lord, for that I have to take instruction.
Lordship may grant until 13/12. High Court was approached yesterday. Kindly give me 1 minute, I requested the High Court yesterday to grant the protection because today everybody has agreed to find a solution. Although I have paid entire money as per the family court judgment. The High Court says, it's a matter before the Supreme Court, I cannot make any order. And it's kept on 13/12.
So we are releasing the matter.
No, my lords, I'll be without remedy, my lords. I'll be without any protection. Lordship, my lords, please.
Protection do you need? What?
It's a complaint against me today. And I can be arrested.
Why?
The lady has lodged a complaint against me. It's a prosecution lodged against me, my lord.
And it's a beautiful shot by Tambe straight into Gupta Sweets. It's a close game now. आजकल बहुत.
Last time, Lordship was pleased to consider there's a complaint against me inquired by the SP and found nothing. Report is given. Thereafter, 2 months later, on the same complaint, we are registered. Same complaint, my lords.
Charged under counsel for the petitioner and the state. None appears on behalf of the second respondent at the time of hearing. We are apprised by the London Senior Counsel appearing for the petitioners that the matter is still alive before the High Court, and the respondent number 2 had appeared before the High Court on
Yesterday, that is 30th October. 30th October.
30th October 2023, and according to him, modus for resolving the dispute is being worked out. Stop. In the light of these developments, we do not want to keep the present petition pending. Stop. In the event the petitioner wants protection from arrest, he shall be at liberty to initiate fresh proceeding before the High Court. Stop. So far as the present proceedings is concerned, this shall be disposed of with an observation that for 2 weeks, no coercive step may be taken against the petitioner by the NCT, government of NCT.
Lordship may say 3 weeks because of the intervening holidays.
3 weeks.
I'm grateful to your Lordship. Immense replies to my lords. Please, Your Lordships.
This order is contrary to the ratio of that Madan Gopal Rungta.
Because, but I'll not make any further submission. Lordship pleases.
1952, what is page 12 or something.
55. 52, 52 page 15. Madan Gopal is the first name versus something else. I'm not able to recollect the second name. Lordship pleases.
Okay.
142.
Yes, it is always Lordship pleases.
28, which is not permissible otherwise.
This is letter in IT.
Letter.
Lordship, kindly indicate any date.
Date will be given as per the letter date.
Oblige, Lordship.
Lord, I am appearing on behalf of the petitioner. Just now I had received the counter. Please give me 2 weeks time. I will consider and get the instruction from the client.
What is the
Counter affidavit he has filed. The other side has filed a counter affidavit that I has received only today only. Lordship I have received. Please give me 2 weeks.
Water body. It was a water body. It was a water body.
Lordship, I will get the instructions only, Lordship, for 2 weeks only. Otherwise, today only I received. Otherwise, I will not.
make construction on?
Lordship, I have the instructions that he
List
is
after 2 weeks. As paid
much
for
obliged.
behalf of the petitioner.
much.
But in this case, the petitioner has completed the work given by the government.
How petition would be maintainable?
Must,
This contractual matter. You are asking for the money,
it's an admitted case.
release of sanction amount and
It is an admitted case of the government.
not admitted. What work you have done, what you have not done, that will be disputed question.
My lords may kindly see page 84 for that.
How petition? File suit if you are aggrieved.
Must, it is in contravention with
Money decree.
Must, there is a judgment of this honorable court in Surya Construction.
Absolutely.
Where my lords have said that if the amount is not in dispute, then writ can be
How do you
filed.
say? How do you say
If my lords may
that?
kindly see page,
Can be filed, doesn't mean must be filed.
if my lords may kindly see page 26.
File.
The order of this honorable court, my lord.
File.
Surya Construction.
File.
Dismissed.
Published. Lordship, my place, Lordship. I'm seeking a short adjournment in this matter.
Why do you not circulate?
Ma'am is not well.
What is
But the
Other matter-
matter is already covered.
Ma'am is not well today.
Huh?
Today only may grant short adjournment.
Who is not well?
Madam,
who is leading you?
Dr. Monica Gusai.
Yes?
Monica.
Okay.
Dr. Monica.
After time appearing virtually. Thus far, on behalf of the petitioner, on the ground of illness of learned advocate on record. It's after 2 weeks. No one is willing to. I mean, one of the. There's a letter.
My lord, there is a letter in 33 as well.
Lordships wanted us to file an additional affidavit, which was filed. After that, the last order that your Lordships had passed, Lordships wanted us to get instructions on the vacancies which were notified. We have it here. But there could be, I don't think there will be consensus amongst the petitioners and the contesting respondents. Lordships may kindly hear the matter.
We'll hear the matter. This has to be
May I only say something? I have clear on behalf of the contesting respondents. There are only 6 of us. There are 10 SLP petitioners or Lordships. We have eventually succeeded in 2 courts from 2018. The matters are pending. It's a very short issue. The only issue really is in terms of whether in the initial notification that was published, there was...
Now, point is, if a situation of this nature arises, in what manner the selection body
Lord, we have stretched it.
take the selection?
We have stretched it to the maximum extent possible. Now, my lords, if your Lordships interfere with the judgment, they are both on the same side. Not they are standing on different.
Unfortunately.
But why you were not here?
So you come.
So now that we are probably more. So, they are both on the same side. So, he wasn't here in the court. So,
He was holding the fort till you came.
no, I'm opposing.
I have been traveling with this matter possibly since just
Correct.
I sat with just
In fact, this case, if your Lordship recollects, the first week when virtual hearing started, before Justice Ramanna, your Lordship sat with Chief Justice Ramanna,
Yes.
and it was one of the first cases your Lordship heard in the... no, Justice Bobde it was. Okay. I stand corrected. There.
What has happened?
No, Lord, it needs to be, unless...
If a situation of this nature arises,
correct.
see, we can cut short this matter or lay down the law. That if a situation of this nature arises, what would be the selection body's responsibility?
So therefore, my Lord, the selection body is entitled to take a call. The corporation, which is a private corporation, was empowered in terms of the advertisement and did take a call and said that because for the first time,
Core subject.
correct. Now they have given justification. They say core subjects are relative to the job you are going to join, and therefore they have given justification.
Then this change of rules midway,
Change of rule
which
will
possibly that principle does not
apply.
hold good
Yes.
anymore,
And now your Lordships have given a judgment that is only for conditions of eligibility, not in the process of selection. That principle will not apply. So the judgments will have to go. Now, either it needs a hearing, my Lord, either I can argue it. I am actually ready to go on just now. Yeah.
On revising.
and hear it out.
Yes, my Lord, in fact, my friend, Mr. Giri, my Lord, his word, nobody can decline. Only 3 people are
He said that we have accommodated as many as possible.
Yes, that's a problem, my Lord. No, my Lord, I have had a meeting with them more than once. Your Lordship may leave that also open. Fix it at 2 p.m. on Sunday, my Lord. We'll come and finish.
2 p.m. we are not very sure. We'll take it after this.
Evaluate.
Whenever your Lordships find that,
At least give us a fixed date because we've been waiting. One way or the other, your Lordships may decide the matter.
Take it on 5th December. 5th December.
As you know. Great. I appear for the
That I wish to file some additional documents.
This has to go on a hearing day, possibly. It's a civil appeal.
Please,
Lord, this is coming arising out of NGT order. So it non-miscellaneous.
I wish to file some additional.
But it's a regular statutory appeal. Please. list on एक first week of December में hearing day में
Very gracious.
36.
Appearing for the petitioner, my lords, settlement talks are going on.
There is a question of settlement talk. Whether you have been permitted to file written statement or not. What is the progress? This is pending since 3 years.
Your lordship, settlement process is going on. We've been paying in installments, your lordship.
If written statement is under the commercial code, possibly the law is it can't be extended. Time only.
What is the status of the suit?
Your lordship, my instructions are that the settlement is in process.
Finalized and we are receiving payments. Complete payments not received. That's kindly grant us 8 weeks time. We will finalize.
So why keep this pending?
Exactly.
You settle. We can't.
Even otherwise, you are settling.
This court, the highest court of the land, can't keep a matter pending because settlement talks are going on.
Your lordship, just 8 weeks time may be granted. Your lordship will.
Dispose of money.
Your lordship, your lordship may grant a pass over. Your lordship, arguing counsel is.
Who is the arguing? You are the arguing counsel for us. You argue.
Your lordship, it is requested, your lordship, if another adjournment can be given, your lordship. 8 weeks time, your lordship.
So why don't you settle? What is the
So almost all the terms and conditions are settled. Some money need to be.
So why do you need this matter to keep on?
Grant us 4 weeks time, madam.
For what reason?
Why should it be kept pending here? What purpose would be served by keeping this matter pending?
Your lordship, Passover may be given, your lordship.
Again, the same thing. See, we agree with the view taken by the High Court. In commercial suits, time to file written statement cannot be
And
extended.
Agree that you have to make payment. You are making payment. So keep on making payment. Why? This matter should be kept pending.
Your lordship, I'll take instructions.
No. No need of instruction. When the matter is called up, paragraph. This matter arises out of a commercial agreement between the parties, and when done, learned counsel appearing for the parties submit before us that settlement talks are at an advanced stage and the petitioners have started already diluting their dues to installment. So far as the judgment on merit is concerned, we do not find any reason to interfere with the same. However, the parties, this court expects the parties to give expect the parties to settle the issues as talks are already going on. The present petition is dismissed with the above observation.
Rights to each.
Councillor. Yes. Next matter.
In the last order, Balu has directed the petitioner to appear in person because he is arguing counsel. He was appearing in person. The last one is on 3rd of October.
You are for?
I am for the petitioner and responding the other one. In this matter, first matter, I am responding.
For the husband.
And I have filed a cross.
For the husband.
I am for the wife.
You are for the wife.
My lords.
So who is for the husband? Because petitioner is husband.
Well, first matter, I am the respondent.
First matter is by the husband.
By the husband, that's correct.
Yes, where is the husband then?
But he was supposed to appear in person today. My lords have granted last time. If my lords sees the order of 3rd of October. If my lord sees the order of last order, 3rd of October.
Petitioner husband, in bracket Gautam Maiti, goes unrepresented. No accommodation is asked for on his behalf. I think he sent some. See, on 31st October, he sent some written submission.
And he has filed many related submissions, my lord. 4 or 5 minutes.
There is on the record document captioned written submissions of the petitioner in person, which appears to have been by him. But we do not find any legal submission contained in the written notes. There are concurrent findings of the first court as well as the first appellate court against him. So, we do not find any reason to interfere with the impugned order, and the petition is dismissed. What is the second matter?
Second matter, my lord, I have challenged this on the grounds
The
of
second matter?
the High Court has dissolved. Yes. I'm the second matter petitioner.
You have been granted 15 lakhs and your daughter 10 lakhs.
Yes. My lord.
So,
But I have challenged, my lord,
how much have you
on
received?
the ground, I have
How much have you received so far?
nothing for me. Daughter has got 10 lakhs.
Last time in the earlier matter, some checks were given.
That is 10 lakhs for the daughter. She has received that. Not for the wife, my lords.
So file execution.
No, my lord, I am not satisfied. I have challenged this, the two judgment I have challenged also. On the count of granting divorce as well as the
What does the husband do?
My lords,
What does the husband do?
he is now working in CCL, Central Courses Limited, as a senior manager.
What is his salary?
More than 3.5 lakhs, my lord.
Have you produced any document?
Because I have tried to get it. Not me.
You said that he is getting this much salary.
Because the instructions are telling. But I client to. Given he has filed an application in his case.
It's 21. What were you doing for 2 years?
That's what I want to argue with.
You should have produced all these documents about the salary before the High Court.
Salary, my lord, I can't get it, my lord. I'm staying in a remote village in Purulia.
File RTI.
And my lord, nobody is with me. I'm on the pension of my father and my brother. He has stopped paying this thing of maintenance also from the.
Where have you, in the trial court, where did you give the particulars of his earning?
If trial court, they have not dealt anything like that. Divorce was not done for me. But what the High Court has done, please see that. Please see that what the High Court has done. That's a page.
10.
No, my lords. Please see page 40 for a moment.
He has a gross 1,80,000 and take home salary of 80,000.
If my lord pay page 40 for a moment of the impugned order. Para 25. Now what happens, may I read so, my lord? Paragraph, page 40, paragraph 25. Now this is long back. The appellant is working as chief engineer, electrical and mechanical in the Bharti area of Dhanbad. On query made, this is what I want to say. On query made to him, he has stated that he has a gross salary of 1,80,000 and take home of 80,000. Appellant has stated that 5 years of service left. Appellant also stated that he has been billed so. So what I say, my lord, this was just against the judgment of this honorable court in Rajneesh.
Leave
We are keeping this open, but at least for 10 lakhs, you may.
However, we make it clear that pendency of this appeal shall not prevent the appellant wife, in bracket Smriti Mohanty, from executing the order permanent alimony granted in his favor, in her favor, by the High Court.
Allowed to file additional documents also, his pay slip and also.
If granted leave, we'll examine.
My lord.
Every hearing, some documents are.
And you can't produce the additional documents which were not there before the High Court.
Oh, I'm saying only his salary slip, nothing else. Because the High Court is what
You could have produced before the High Court.
That's correct, my lord. But what the High Court has said on query made, that cannot be done, my lord. They have to file an affidavit.
Whatever it may
This
be.
liability is an asset. That is how.
You could have also filed.
But that's what this court has said, my lord, in that case.
Anyway.
Yes. Obliged. Obliged.
In this matter, Ishwar is the husband of the deceased wife.
We have executed a document of divorce.
There was no existence of wife-husband relationship.
The court has granted divorce on the basis of a decree of divorce, agreement for decree of divorce before the sub-registrar, your lordship.
How can?
There has to be existence of husband-wife relationship for the family.
Yes, your lordship. Marriage took place in 71. They lived together up to 92. Due to differences, they executed a decree of divorce.
Other respondents are served.
Yes, your lordship, but they do not.
None represents the other respondents. So, on going to the judgment under assailed in this petition, we do not find any point of law involved warranting in invoking of jurisdiction under Article 136 of the Constitution of India. The present petition is hence dismissed.
Congratulations.
Please, Milord.
Yes.
Milord,
Delay condone. How many days delay? Huh? Since we are dismissing the petition, is delay condone.
please, Milord. Milord, I am appearing for appeal, Milord. Statutory appeal, Milord. On the same issue.
Very appeal, but the SEBI and the appellate authorities.
Number of other petitions are, Milord. There is a direction where lots to list. A bunch of petitions are there apparently on the similar issue, Milord.
Similar issue, common.
Parties.
What about the other parties? Because this is.
They are before the court in the other petition, Milord.
Only 3 persons are in appeal, but the others have not filed an appeal even before the tribunal. So whoever, my lord, had appealed before the tribunal and lost are before this.
Is there any appeal pending arising out of this same common?
No, my lords.
Not the same order, Milord, but on
Similar issues may be pending in hundreds of cases.
directions of your lordship is to place every matter on the similar issue to
It will mainly depend on the facts.
Anyway,
Penalty orders.
an officer of the court is duty. Just to point
dismiss.
Milord, let me argue my case, Milord. It's a principle. Your lordship says it should not. No,
Okay, you have concluded.
no, Milord. I am saying that similar matters are pending before your lordship.
You will not tag with that. You may argue on that.
Yes.
You may argue on that.
Yes, Milord. On the principle, we raised 2 issues, Milord. One was on the delay, and second was, Milord, on the disproportionate of the penalty, Milord, order. There is a lordship may have see the volume 2, Milord. Volume 2, Milord.
Yes.
Lordship may see, Milord, volume 2, page 283 of the AO order, Milord.
We will hear it out on a regular hearing day.
On the aspect of delay, my lord, this honorable court already said it would not be inclined to interfere. Limited notice only on the proportionality, my lord, this honorable court was pleased to grant. Only to bring to your lordship's notice, covered by 2 judgments of this honorable court, where this honorable court said proportionality cannot be.
On a hearing day.
Yes.
1 minute. 30th November. List on. Huh? Statutory applications. If we dismiss on the first. Appeal admitted. List on 30th November.
Yes, deposited the penalty.
Only difficulty is.
Yes, Lord, under protest, all penalty has been deposited, my lord. But on question of law,
I'm only placing one concern. There are no difficulty about the matter being heard. The lordships were to admit the matter. But what happens is whenever there's a penalty that is being imposed, whenever my lord, someone files a...
You tell us if it's a statutory appeal.
Yes.
Is there any...
Your lordships
there has to be a formal admission, but can we...
Yes, no, it can be dismissed. Your lordships have held in two judgments that if the only point that is now remaining for consideration is proportionality of penalty,
no, normally dismiss, but again we'll have to dismiss the appeal only.
Yes, it means that appeal, my lord, would not be maintainable because it is maintainable only on a substantial question of law that arises for consideration. Proportionality would not, unless, my lord, they are able...
Okay, we'll examine that, yes.
But lordships keep it at the same stage because if lordships admit, they will say similar matters admitted and other matters will get taxed.
Instead of admitting, we'll hear some.
That's my only request.
List some appeal on Thursday,
Obliged.
No admission.
Deeply.
Let's on item 40. I am requesting for a week's accommodation in this matter on behalf of respondent here.
Because
I have recently filed.
Last date, they made a request saying settlement talks are going on. And they have not changed the council.
Have the order been complied with?
No, there was no settlement talk. They changed the council now. Now they changed the council. It's only to delay the proceeding. One submission. And also it's a repeated, there's a second.
What is the order?
So they had made a submission that settlement talks are going on, which is recorded in your lordship's order.
Yes?
I'm only requesting for a week's accommodation.
No, let us see if you have complied with the order.
Your lordships had recorded. I ordered it at 10th October. London Council for respondent number 1.
You take us through the order, the violation of which is?
On the contempt, my lords. First, can I request your lordships to take item 40.3, which is a new contempt petition, which is contempt petition civil number 1158.
40.3.
40.3. Contempt petition civil number 1158 of 2000.
Tell us in a nutshell what is
yes, the original dispute in the special petition is that the petitioner was a presbyter in a church. He was suspended. He filed a suit challenging the suspension. There was an interim order passed. There was an interim order.
Christians fighting everywhere.